Mohammed Saheb Hussain, Kolikonda, Sharad Babu, as well as the Motamari, Sri Vidya. So now, without wasting the time, let me go to the point. Yes, this is the thing which I want to share in today's class. Is it visible? The screen is visible. The screen is visible. Participants, the screen is visible.
Sir, your voice is breaking.
My voice, forget about my voice. Now screen is visible.
There is disturbance in your voice, sir.
No, because my voice will not be recorded. Kolikonda Sharad Babu voice will be recorded.
Voice breaking.
Because I will be silent.
Not clear.
Yes, now it. Kolikonda,
Disturbance, sir. There is a disturbance.
go to the first question. Sharad Babu, go to the first question. Sharad Babu, go to the first question.
When the participants are less only, why is the problem, sir?
No matter, because
No
sometimes
doubt.
disturbance would be there. But after some time it will be rectified. Okay, no matter.
Yes, sir, I am ready.
Go ahead.
Whether the voice will be, whether
Your
the
voice is very
voice
much
will be
clear.
or not, I don't know, but
Your voice is very much
okay,
clear.
sir,
Go ahead.
show it. Okay, sir. According to section 2B of CRPC 1973, charge includes option A, heading of charge, option B, any head of charge when the charge contains set, C, any head of charge when the charge contains more heads than one, D, all the above.
Option C.
Option C is the right answer.
Okay.
Sir, 4 questions completed, sir, already.
Okay, now go to the fifth
We
question.
have already completed 4 questions.
Go to the fifth question.
Yes, sir. Scroll up, sir.
Already scrolled.
During the pendency of a suit relating to a house, the defendant is about to leave the local limits of the court.
But you
with
did
an
not read the
intention
fifth
to
question.
base the suit.
Fifth question.
Okay, sir. I will come to fifth question later, sir. The plaintiff files an application under Order 38 Rule 1 for the arrest of the defendant. Now the defendant A cannot be arrested, B can be arrested, option C, option D, no
options are
options,
given.
only A, B options are there.
Cannot be arrested.
Yes, cannot be arrested. A is the right answer.
Okay, go to the fifth.
Now fifth question, sir. Just scroll down.
Already.
Yes, state the correct sequence. A, issue, trial, arguments, pleadings, decree, judgment. B, pleadings, trial, issues, arguments, decree, judgment. C, pleadings, issues, arguments, trial, judgment, decree. D, pleadings, issue, trial, arguments, judgment, decree.
Option D. Pleadings issued, argument, judgment, decree.
Summons
Option
issues.
B. Option D.
Option D is the right answer. Pleadings, issues, trial,
Yes.
arguments, judgment, decree.
Yes, D is the right answer. Seventh question.
Seventh question, when the immovable property of one person is by the act of parties or operation of law made security for the payment of money to another, such transaction is A, pledge, B, accession, C, marriage, D, charge.
Mortgage.
Charge.
Yes, option D, charge is the right answer.
Okay.
Next, Ninth question.
Eighth.
Eighth question. A gift made in expectation of death is known as option A, universal gift, option B, onerous gift, option C, resumable gift, option D, donation mortis causa.
Option D, donation
Option
mortis
D,
causa.
donatio
Option
mortis
D,
causa, section
donatio
129.
mortis causa. Mortis means death. So that itself shows that the gift is in expectation of death. Now, ninth question is a contract to do or not to do something. If some event collateral to such contract does not happen, is known as option A, wagering agreement, option B, quasi contract, option C, contingent contract, option D, impossible contract.
Option C, contingent contract.
Yes. Option C, contingent contract. That is the right answer. Next, 10th question. An agreement where the parties express opposite views regarding an uncertain event and which results into a gain to one person at the loss of another person is known as A, wagering agreement, B, contingent agreement, C, continuing agreement, D, standing form contract.
A, wagering agreement.
Shall I show the key?
A, wagering agreement.
10th A is the right answer.
For which question, sir?
10th is the A is the right answer.
For 10th question, okay,
Yes.
wagering contract. Now, 11th one is when an instrument in writing does not express the real intention of the parties due to fraud or mutual mistake of the parties, a suit can be instituted for A, cancellation of instrument, B, rectification of instrument, C, declaration of instrument, D, rescission of contract.
B, ratification of instrument.
Yes, B, right answer. That is rectification of instrument. 11th, for 11th, B is the right answer. 12th question is, what is the time limit for institute a suit for recovery of the property on the basis of disposition under the provision of CPC when the plaintiff was disposed of a house by the defendant? Option A, 60 days from the date of disposition. Option B, 6 months from the date of disposition. C, 6 years from the date of disposition. E, none of the above.
Option D,
D,
none of the above.
actually in place of E,
None of the above.
Option
D
D.
should be there.
D, none of the above.
None of the above. Actually, there should have been D, but by typographical error, E appears, but that should be taken as D. So D is the right answer, none of the above. Now, 13th question. The involvement of 5 or more persons is essential for the offense of A, theft, B, extortion, C, robbery, D, dacoity.
D, dacoity.
D, dacoity is the right answer. Should involve 5 or more persons for the offense of dacoity. Now, 14th question, 3 persons, A, B, and C went to a bank. A stood outside the bank holding a revolver with him and watching at the road. B and C entered the bank and asked the cashier by showing revolvers at him to hand over the cash to them. On the refusal to do so, C shot at the cashier and took away money from counter. Now, A, C is liable for the murder of A and B are liable for abetment. B and C are liable for murder and A is liable for abetment. C, A, B and C are liable for murder. D, none of them is liable because it is not a murder but only culpable homicide, not amounting to murder.
Option C, A, B, C are liable to murder.
Shall I show
Yes.
the key?
No need, sir.
Give the answer.
C is the right option. That is the option C is the right answer. A, B, and C are liable for murder. Though A and B did not directly participate in the murder, They are also treated as murderers along with C. So option C is the right answer. A, B, and C are liable for murder. 15th question. Sans recourse endorsement means A, endorsement with limited liability, B, endorsement without liability, C, endorsement with absolute liability, D, endorsement with conditional liability.
Option B, endorsement without liability.
Option
B. B, B. B for bat.
Yes, option B is the right answer. Sans means without. The meaning for sans is without. So here endorsement without liability directly appears. So that can be taken as a clue. 16. What is the punishment under section 138 of NI Act? A. Imprisonment up to 2 years or with fine which may extend to twice the amount of check, or with both. Imprisonment up to 2 years and with fine which may extend to twice the amount of check. C. Imprisonment for not less than 2 years and fine of 10,000 rupees. D. Imprisonment for not less than 2 years or fine of 10,000 or with both.
Option B. Fine.
Option A is the right answer. Imprisonment up to 2 years or with fine which may extend to twice the amount of check, or with both. 17th question. The limitation period for enforcement of perpetual injunction is option A 1 year, option B 3 years, option C 12 years, D none of the above.
Option C, 12 years.
12 years.
Option D is the right answer, none of the above. 18th question. What is true with regard to application of Limitation Act 1963? 1. It has no application to Section 25 of Indian Contract Act 1872. Option 2. This act shall not apply to any suit or other proceeding relating to marriage and divorce. Third statement is where any special or local law prescribes for any suit, appeal, or application a period of limitation different from the period prescribed by the schedule. The provisions of Section 3 shall apply as if such period were the period prescribed by the schedule. 4. The provisions of Section 4 to 24 shall apply unless expressly barred by special or local law. Now scroll up, sir.
Option 1 is the right answer. Shall not apply to Section 25 of Indian Contract Act.
Sir, please scroll up. So here are options. Option A, 1 and 2 are correct. Option B, 1, 2, 1, 3 and 4 are correct. Option C, 1, 2 and 4 are correct. Option D, 1, 2, 3 and 4 are correct.
Option C, 1, 2, 4 are correct.
Option D is the right answer. All 1, 2, 3, 4 are correct. 19th question.
D is the right answer.
D is the right answer.
Okay.
All statements are right. 19th question. An easement right is a right A in rem, B in personam.
A, sir.
Option A.
Right in them.
Option B is the right answer, in personam. Sir,
Yeah.
I want
Shall I show the key? 19th, the key is
actually
B.
in key it is given as personam.
But the
No need
answer
to
is
show,
yes.
sir.
It is rem, not person.
Okay, let me
Judgment
clarify
will
it.
be
Let
in
me
red,
clarify
sir.
it. Okay, just a minute.
I too agree with the participant.
Yeah, let me clarify it. Let me check it. Right in rem is against a,
Right in rem, sir. No, right in
Easement.
yeah,
easement.
yeah.
Easement.
Acha. Right in
Easement is right in
easement.
rem or personam.
Easement. Okay. The easement right be taken away. What is an easement? Okay, let me see it. An easement is a right benefiting a piece of land known as a dominant tenement and is enjoyed over the land owned by a third party, often the neighboring land known as the servient tenement. So only the people.
You type it, sir. Whether is it personam or right in rem?
Yeah, that is the way that I made it. Right in easement is rem or personam. Okay. Restrictive covenant are contractual and therefore primary one
Yes,
enforceable
that
in
is
the
rem
person,
right.
whereas the easement confers in a right rem, which is enforceable against the rest of the world. So rest of the world is the right answer to me.
Yes, right in rem is right answer.
See, here it is given the right of easement is the right in rem.
The key
Is
is
it
wrong,
clear?
sir.
The right of easement is a right in rem. Is it clear?
Yes. Yes.
Very good.
Yes, sir.
Okay, next.
Yes, sir.
Let me go.
Now,
Okay. What is the question number?
question number 20, sir.
20?
Yeah.
Yes, next.
My knowledge, it should be 20.
Read the 20.
Of the following, which
Sir,
is
why you
not
need to
a
open,
mode
sir?
of acquiring easement? A. Easement by law. B. Easement by grant. C. Easement by prescription. D. Easement by necessity. Which is not a mode.
Easement by law.
Yes, option A. Easement by law is the right option. That is the right answer. A is the right answer. 21st question. Whether principle of res judicata applies to claim petitions under Order 21, Rule 58. A, no. B, yes. These are the only two options.
Option
Option B is the right answer. Whether principle of res judicata applies to claim petition under Order 21, Rule 58. Yes. Yes is the right answer. So option B is the right answer. 22nd question. X files a suit against Y and then the suit is called on for hearing. Neither party appeared in the court. The court dismissed the suit under Article 9, Rule 3. Thereafter, X may A. File a fresh suit subject to the law of limitation. B. Apply to the court for restoring the suit by showing a sufficient cause. C. Both A and B. D. Neither A nor B.
both A and B.
Option
Option C is the right answer. Both A and B. They can file a fresh suit subject to the law of limitation as well as apply to the court for restoring the suit by showing a sufficient cause. 23rd question. Every police officer making an investigation shall enter day-to-day proceeding for a case in a diary called A. General diary, B. Special diary, C. Duty diary, D. Case diary.
General diary. A. Option D, case diary.
Option D. Always it is case diary. Should have remember it. 24th question. Mr. Kumar voluntarily causes hurt to Gautam. Gautam goes to police station to the lodge FIR. The concerned police officer refuses to record the FIR whether the act of the police officer is valid. A. No. B. Yes.
A. No.
Obviously, A is the right answer. No is the right answer. He cannot refuse to record the FIR. 25th question. Khan commits an offense of grievous hurt in Hyderabad. However, he makes a confession before the judicial magistrate at Adilabad, who has no power to try the case. Whether the confession recorded after the following procedure by the magistrate is valid. A yes, A no, B yes.
Option D, yes.
Option B is the right answer. Yes. Yes is the right answer. So option B is the right answer. 26th question. The
Can I
Limitation Act.
read? Can I read 26th?
Yes.
Okay, now you be ready with the answers, right answer. 26th question. The Limitation Act 1963 applies to the proceedings before option A, courts, option B, executive authority, C, option quasi-judicial tribunals, D, none of the above.
A court.
A court.
Yes, option A is the right answer, sir. The remaining authorities or tribunals, the Limitation Act 1963 does not apply to them.
Good. 27th question. Section 5 of the Limitation Act deals with option A, of limitation, option B, extension of the prescribed period in a certain cases, C option, doctrine of legal disability, D option, none of the above.
Option B. Prescribed period in certain cases.
Option B is the right answer, extension of prescribed period in certain cases. That is Section 5 of Limitation Act says.
28th question. The provision of the improvement made by the bona fide holders under defective title is dealt in option A, section 50 of the TP Act, option B, section 51 of the TP Act, option C, section 53 of the TP Act, option D, none of the above.
Option B. 51. Option B.
Option B is the right answer, Section 51 of TP Act.
Okay. Next question, 29th question. Of the following which is misfit matching? A, section 81 of the TP Act, that is marshalling securities. B, section 82 TP Act, doctrine of contribution. C, section 92 of the TP Act, doctrine of subrogation. D, section 93 TP Act, charge.
Option
93.
Yes, option D is mismatch. The 93 section does not match with charge. So option D is the right answer. The remaining are correct matches.
Okay. 30th question. According to section 60 of the TP Act, a clause on redemption is option A, valid subject to certain conditions. B, absolutely valid. C option, voidable. D option, none of the above.
D, none of the above.
None of the above.
Option D, none of the above is the right answer.
Okay. 31st question. Of the following which is a misfit matching? A, agreement to supply goods from time to time, continuing offer. Option B, responsibility of the finder of the lost goods agent. C, betting agreement, wagering agreement. D, an agreement to pay 100 rupees if it rains on Sunday, contingent contract. As a misfit.
The responsibility of fine daily notice in
Yes, option B is the right answer. Responsibility of finder of lost goods does not match with agent. All the remaining A, C, D correctly match.
Okay, 32 question. A contract by which party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called option A, contract of guarantee, option B, contract of insurance, option C, contract of bailment, option D, contract of indemnity.
option D, contract of indemnity.
Yes, obviously D is the right answer. Contract of indemnity.
33 question. According to section 69 of the Indian Partnership Act 1932, an unregistered firm can file a suit against an outsider for recovery for an amount not exceeding 100 rupees. Option A, yes. Option B, no.
No.
Option B, no.
D, no.
Option B, no is the right answer, sir.
Okay. 34th question. An agency coupled with the interest can be revoked by principal. Option A, yes. Option B, no.
Option B, no.
Option B, no is the right answer, sir.
Okay, supplementary question. A person cannot be physically present in all the places, but under certain condition, a person can be physically present in all the places in the world. Tell me, which relationship should be there? Master and servant, partner and other partners, employer and employee, or principal or agent?
Principal and agent.
Principal agent.
An agent can represent the principal in various places in the world. Is it clear?
Both are treated, all are treated as persons.
Okay, now next. Doctrine of estoppel can be applied against a minor. Option A, no. Option B, yes.
No.
Estoppel, no.
Option A, no.
No. A.
Confirm, Konikonda.
Option B, option A, no is the right answer.
Okay, okay.
It cannot be applied against a minor.
Okay. 36th question. As per section 3 of the Indian Evidence Act, fact means and includes A. Option physical facts, B. Psychological facts, C. Both A and B, D. Neither A nor B.
Option C.
Option C is the right answer, sir. Both A and B.
Means physical as well as psychological facts.
Both physical facts and psychological facts.
37th question. Can an evidence obtained by the committing the offense of theft be admitted in a case of criminal nature? Option A, yes. Option B, no.
Yes.
Option A is the right answer, sir. Yes.
Okay. 38th question. A tape record of speech is A. Documentary evidence, B. Oral evidence.
Documentary evidence.
Documentary evidence.
Very clearly, it is documentary evidence. So option A is the right answer.
39th question. Mr. Lallu, an accused, writes a letter in his own handwriting with his signature addressing a police officer that he murdered his wife. The letter was found near the dead body of his wife. Is the confession made by the Lallu in the letter admissible in the evidence against him? Option A, yes, the letter is relevant. B, no, it is not relevant.
Yes. Relevant.
Option A is the right answer. Yes, the letter is relevant.
Okay,
So it is
40th
in his
question.
own handwriting, and it is found near his murdered wife.
48th question. Mr. Bhallu is accused of a murder. The police have produced an axe from a place and he said that it was the weapon with which the deceased were killed. Whether this statement made by him is irrelevant under the section 27 of the Evidence Act. Option A, yes, it is relevant to the extent of acts. B, no, it is not relevant as section 27 is not applicable to the present case.
Option A, yes, relevant to the extent.
Option B. Option B.
Option B is the right answer. No, it is not relevant as per section 27 is not applicable to the present case.
Okay. 41 question. Mr. Varlu fires a Venkat with an intention to kill him. Venkat sustained the serious injuries. He lodged a FIR against Varlu and subsequently Venkat dies due to the injuries. Whether this FIR can be treated as a dying declaration? Option A, yes, the FIR can be treated as a dying declaration. B, no, it is not statement made by him regarding his death.
Option A.
Yes. Option A.
Yes, option A is the right answer. Yes, this can be treated as FIR. This FIR can be treated as a dying declaration.
And earlier classes I also told you, what is the landmark case law of the dying declaration of the Privy Council?
Queen versus Abdullah.
Appreciate your memory. Yes, a good clap. 42nd question. How many witnesses are required to prove a criminal case beyond all reasonable doubts? Option A, minimum 2. Option B, minimum 3. Option C, minimum 4. D, none of the above.
Option D. None of the above.
Why?
Option D, none of the above is the right answer.
Why?
Why?
Quality is important, not quantity. According to section 134 of
There is one statement is there. Let the 99 convicts should be released, but one innocent cannot be convicted. So the principle in the criminal law is beyond reasonable doubt. Repeat.
Beyond all reasonable doubts.
Yes. 43rd question.
Always the benefit of doubt goes to the accused one.
Yes, that's why we say beyond the reasonable doubt, and just before say 99 and 1. 43 question. Any question suggesting the answer which the person putting it wishes or expects to receive is called option A, patent question, B, latent question, C, leading question, D, misleading question.
Option C, leading question.
Option
Yes.
C is
Am
the
I
right
right?
answer, leading question.
Can you give an example for the
Yes.
leading question? One example. I think you are present there at the time of the offense, and is it not?
Yes.
Because
So
you
the
are forcing the witness to say yes or no. Means you are convincing me. So that leading question should not be asked over there. 44th question. As per section 5 of the Evidence Act, evidence can be adduced during relating to a dash, a fact in issue, B, a relevant fact, C, both A and B, and D, neither A nor B.
Option C.
Option C is the right answer, both
Because in
A
the
and B.
earlier question that say it's about the fact and it's about the psychological answer. So when you go through it, then naturally the C would be the right answer. 45th question. Under section 3 of the Evidence Act, evidence means A, documentary evidence, B option, ocular evidence, and C option, neither A nor B, and D, both A and B.
Option A.
Option D is the right answer,
Both A and B.
A and B.
Okay, now supplementary question. What did you understand by the ocular evidence?
I don't know.
Eye
I
evidence. Ocular means eye.
ophthalmology.
Yeah. Eyewitness.
Next, 46th question. As per section 167, subsection 5 of the CRPC, a magistrate can pass an order of stopping further investigation and discharge the accused in a summon case if the investigation is not completed within a period of months from the date on which the accused was arrested. A, 2 months, B option, 3 months, C option, 6 months, D option, none of these.
2 months. Option B.
Option C is the right answer, 6 months.
6 months is the right answer. Okay. Next, 47th question. As per the section 357, capital A of the CRPC, Amendment Act 2008, within parentheses, who is the authority to decide the quantum of compensation payable to the victim? A, the trial court, B, the session court, C, the high court, D, the district or state legal service authority.
Option D, district or state legal.
Option D is the right answer, the district or state legal services authority. DSLA or SLSA.
Okay. 48th question. What is true with regard to the plea bargaining? A, it has application where the offense attracts imprisonment exceeding the 7 years. B option, it is applicable where the offense affects socio-economic conditions of the country. C, plea bargaining will not be allowed where the offense has been committed against a woman or a child below where the offense. D, all of the above.
Option C.
D. All of the above.
48 for 48th question, D is the right answer, sir. All of the above.
That means all options are correct.
Yes.
Not correct, sir.
What is the true with regard to
all-
not correct?
all-
Yeah.
All three answers are correct, sir. What is true with regard to plea bargaining?
Yes.
Not
Means
true is not-
all three options are correct.
Yeah.
Okay. Any doubt? Shall I proceed? Shall I proceed?
Yes.
See, unless you give the answer, I cannot move. I told you already. 49th question. Whenever a case is tried summarily, the sentence of imprisonment shall not exceed A, 2 months, B option 3 months, C option 6 months, D option none of these.
6 months.
3 months.
Option B is the right answer, 3 months.
3 months. Summary.
What is meant by summary trials? Participants,
should be
Srividya,
it should be tried very early, very immediately.
Srividya is present,
Yes, sir, I'm present, sir.
but you are not giving the answer. But I expect the answer from you immediately. Okay, next. 50th question. A, B, and C are charged by a magistrate of the first class with and convicted by him of robbing D. A, B, and C were afterwards charged with and tried for dacoity and
Now,
okay, I repeat because it's not recorded.
Under section 300 CRPC.
Please,
option B,
please
they
wait,
cannot
it is
take
not
protection.
recorded. I repeat, 50th question. A, B, and C are charged by a magistrate of the first class with a convicted by him of robbing D. A, B, and C were afterward charged with and tried for the dacoity on the same facts. Now, option A, they can take protection under section 300 CRPC. B, option, they cannot take protection under section 300 CRPC. Should.
B.
Option A.
Yes, option B is the right answer. They cannot take protection under section 300 CRPC.
Is it clear?
Yes.
Say yes. Is it clear? Say yes.
Yes, clear, sir.
Good. 51st question. A and B are the joint owners of the horse. Takes the horse of B's position, intending to use it. However, A sells the horse and appropriates the whole proceeds to his own use. Now, A is guilty of A, no offense. B, criminal breach of trust. C, mischief. D, dishonest misappropriation.
Option D. Dishonest misappropriation.
Option D is the right answer, sir. Dishonest misappropriation.
Supplementary question. Horse is which gender? No host, only participants.
Male.
WRONG. A male horse is called stallion. A female horse is called mare. M-A-R-E, mare. 52nd question. A and B are the joint owners of a horse. A shoots intending thereby to cause wrongful loss to B. Now A is guilty of A, no offense. B option, mischief. C, criminal breach of trust. D, criminal misappropriation.
Option B. Mischief.
Option B, mischief is the right answer. What is
Right
it, sir?
answer is mischief.
It amounts to a very little criminal action.
Okay. 53rd question. Section 84 of the IPC provides for A, medical insanity. B, legal insanity. C, both medical and legal insanity. D, none of the above.
Option B. Legal insanity.
Medical and legal insanity, sir.
Option B is the right answer, sir. Legal insanity.
What is meant by legal insanity?
Law has prescribed some rules for insanity.
Through operation of law, we can say insane person. Okay, next, 54th question. Abatement under the section 107 of the IPC can be constituted. A, instigate. B option, conspiracy. C, intentional aid. D, all of the above.
D. All of the above.
All of the above.
Srividya, I did not see your name there. Only Sumalata is giving the answer. Sir, I know
Sir,
you.
I'm
I
not-
don't want.
sir,
I
I'm
don't want to
not
make it
quick.
out. No, you are a participant now. You are not a host. 55th question. Rama, an officer of a court of justice, was ordered by the court arrest Rahim after due inquiry, believing Rahimuddin to be a Rahim. Rama arrest Rahimuddin. Rama is exempt from criminal liability under A. Section 76 IPC. B. Section 78 IPC. C. Section 79 IPC. D. None of the above.
Option A, 76.
76 of IPC.
Golukonda.
Yes, option A is the right answer. Section 26 IPC according to section
Okay.
26 IPC.
Golukonda Sharad Babu, continue from 56th.
When two or more persons by fighting a public place disturb the public tranquility, they are said to commit an offense of A. Affray, B. Rioting, C. Nuisance, D. All the above.
Option A, affray.
Yes, option A is the right answer. Affray is the right answer. Next, 57th question, section 34 of IPC. A. Creates a substantive offense. B. Is a rule of evidence.
Option B is rule of evidence.
Option B is the right answer. Is a rule of evidence.
Supplementary question. What is section 34? Supplementary question.
Common.
Common intention. Okay, next.
58th question. Culpable homicide is not murder. It is if it is committed under A. Grave and sudden provocation. B. Self-intoxication. C. Irresistible impulse. D. All the above.
Option grave and provocation.
Option A is the right answer. Under grave and sudden provocation, if one commits murder, it is culpable homicide.
Now the supplementary question. What is the landmark case law in the grave and sudden production they have used at the time, but the court rejected it? What is the landmark case law? For the grave and sudden provocation, there is a landmark case law. And a Hindi movie also made, Akshay Khanna. Akshay Kumar is the hero. A naval officer.
Yes, sir.
K.M. Nanavati versus State of Mumbai.
Yeah.
Repeat.
K.M. Nanavati versus State of Bombay.
That is the last case law regarding the jurist. After that, jury system is abolished. Next, 59th question.
For an unlawful assembly under section 141 IPC, the minimum number of persons required is A. 2, B. 3, C. 5, D. 7.
Option C, 5.
Option C, 5 is the right answer. Now, 60th question. Causing disappearance of evidence of offense or giving the information to screen offender is an offense under A. Section 200 IPC, B. Section 201 IPC, C. Section 202 IPC, D. Section 203 IPC.
Option B, Section 201 IPC.
Option B is the right answer. Section 201 IPC.
At any time it is going to be closed. So, can we make the class tomorrow or today we'll wind up? The remaining questions.
As of our schedule, today is the last day, sir.
Yes.
So we shall complete as many as possible, sir.
Okay, go ahead.
What is the punishment for the offense of theft? A. Imprisonment up to 3 years of fine. B. Imprisonment of not less than 3 years of fine. C. Imprisonment 3 years or fine. D. Imprisonment up to 3 years or fine or with both.
Option D.
Option D is the right answer. Imprisonment up to 3 years or fine or with both. 62nd question. Can there be more than one preliminary decree and one final decree? A. Yes. B. No.
Option A, yes.
Option A, yes, is the right answer. 63rd question. Whether the doctrine of legal disability applies to preemption suits. A, yes, B, no.
No, B.
Option B is the right answer. 64th question. Whether an interpleader suit can be instituted by the agent against principal. Yes, no, yes with the third person claims. When a third person claims right through principal.
Option C.
Option C, yes. When a third person claims right through principle is the right answer. 65th question. Whether an ex parte decree can be challenged by way of appeal. A, no. B, yes.
Option
Yes, B.
Option B is the right answer. Yes, it can be challenged by way of appeal. 66th question. When a material proposition of act of law is affirmed by one party and denied by the other, it is known as A, an assertion, B, an allegation, C, an admission, D, an issue.
An issue.
an
Option.
Yes, an issue is the right answer, so option D is the right answer. 67th question. Mr. Vinod of Adilabad makes a proposal to sell his house situated in Vikarabad to Vikram of Nizamabad. In the sale agreement, they provide a clause stating that all disputes arising out of the transaction are to be decided by the court of Nizamabad. Thereafter, when a dispute arises, Vikram must file a suit. A in the court of Adilabad, B in the court of Nizamabad, C in the court of Vikarabad, D all of the above.
All of the above.
option Vikarabad.
B, sir.
Option C in the court of Vikarabad.
Where
That
the
is the right
property?
answer.
Property inspection.
68th question. Every warrant of arrest issued by a court remains in force for A, 6 months, B, 1 year, 3 years, none of the above.
Option D, none of the above.
Option D, none of the above. It is always, the warrant of arrest is always in force. There is no time limit for it. 69th question. According to Order 6, CPC pleading shall mean A, plaint, B, written statement, C, plaint and written statement, D, plaint or written statement.
Option D, plaint or written statement.
Option D is the right answer.
Jai Hind.